we're going to do some just land use control questions tonight. These are things like easements and encumbrances and zoning and police power and all that kind of thing. Isabel likes to fish and her neighbor gave her the right to come fish in his farm pond once a week. This is known as, is it a license, an appurtenance, an easement, or covenant? What do you guys think? You guys knew this one right away. Lots of people jumping in here. Now remember, they're letting Isabella have a license, right? A license. Now, why is it a license and not an easement? Anybody know why this is a license and not an easement? And the reason why is because it's revocable, right? We can get rid of the license. Like, okay, for example, if I gave Stacy a license to fish in my backyard, and one day Stacy made me really mad, and I'm like, Stacy, don't come back. I'm allowed to do that with a license. It's revocable by me. Or if I were to die and someone else inherited my house, one of my kids inherited my house, then what would happen would be that the license would die with me. I know it's kind of morbid, but the license would die off with me. So the license is not the same as an easement, which would just kind of continue on maybe forever and ever, right? Easement could be appurtenant. It could run with the land. So that's that second word, appurtenance. What does appurtenance mean? It runs with the property. And many times an easement runs with the property. A license would not. It's only with that person to the other person. But an easement might stick with the property. Even if I sold it to William, the easement might stay with the property. The local zoning rules state that the construction of new homes requires a 25-foot setback. Larry's lot size will not allow for this much of a setback without an undue hardship on Larry. Larry will likely request a what? What's Larry going to ask for? Is it spot zoning, variance, freehold estate, or a deed in lieu of foreclosure? What do you guys think? Everybody kind of got that one pretty quick, right? That's the variance. But now let's stop and think about the other ones here. What does it mean when I say deed in lieu of foreclosure? I know it's not the answer to this one. Variance is when I'm asking to make a change to the zoning rules. I'm asking them to bend the rules for me, usually because whatever the rule is creates a hardship for me. But deed in lieu of foreclosure has nothing to do with that. But I want you guys to know what a deed in lieu of foreclosure is. And a deed in lieu of foreclosure works like this. If my property is on the way to the auction block, right? And my property is in foreclosure, I know I can't redeem it. I can't save it. Things are just going badly for me. And I don't want to be dragged through the mud. I don't want them to have to take me to court and do all this stuff to try to foreclose on me. I just say, okay, I get it. And I hand the deed over to the bank. And states that do mortgages where I hold the deed, even though there's a loan on the property. If I just hand the deed over to the bank and don't make them fight me for it in court, that's a deed in lieu of foreclosure. Now, why would we do this? Well, a couple of reasons. The big reason is we just don't want to go through it. We just want to say, okay, the heck with it. And we want to walk away. That's one reason. But another reason why we might do deed in lieu of foreclosure is in states like mine, I live in Ohio. If they're going to foreclose on me, they have to take me to court, hire an attorney, go through the whole legal foreclosure process. That costs money. And guess what? That cost is passed along to me in the end, right? The borrower. So whatever cost they don't recoup from the auctioning of my house, they can, at least in some states, come after me for a deficiency judgment. So as that piles up, that deficiency judgment could grow, and it may be financially beneficial for me just to say, here, let's just call this a day, right? So just wanted to go over that with you guys real quick. The city of Orlando has enacted rules and regulations about the construction of buildings that everyone must follow to ensure that the buildings are safe and built correctly. These are called, are they eminent domain, condemnation, building codes, or actual annexation? Yeah, building codes, right? These are kind of a little bit easy. We're starting off with some easier ones. So building codes, those are the things that are going to make sure everybody's safe and sound in their house. We're going to pull a building permit usually. The inspector from the government's going to come along and make sure that the construction was done correctly before they go ahead and sign off on it. Very good. So Olivia's charged property taxes based upon the value of her property. This is known as, is it an ad valorem tax, condemnation tax, sales tax, or income tax? Yeah, ad valorem taxes based on the value. So if Christina lives next door to me and Christina has a more expensive home than I do, then Christina's going to pay more taxes. It's based on the value, ad valorem, right? Very good. All right, next, a developer must get a blank approved before building houses in a new subdivision. Is this a planned unit development, a plat map, a title exam, or a variance? Christine said, yeah. Yeah, the plat map. Now, the plat map. Okay, we're talking about subdivisions here, right? What is the name of the legal description? What is the type, I should say, of legal description that would be included in my deed if I lived in a subdivision where there was a plat map? What kind of legal description sticks to that? Anybody remember that one? Remember, we've got meets and bounds, government rectangular survey system, lot and block. Which one is it? So, yeah, there you go. Early got it. Yes, the lot and block, right? If I live in a subdivision, I would have a lot and block legal description in my deed describing where my property is. Now, if they wanted to go ahead and put together this plat map and they wanted to put together all of these legal descriptions, who would they call to write those? Whose job is it to make sure that those legal descriptions are put together? What's the name of that career, I guess? The surveyor. Yeah, exactly. The surveyor. The surveyor would come out and do a survey on the property, say, here are the lot lines of this property. Yes. Now, let's stick with this because we're on a roll here, right? What if we're talking about these legal descriptions a little bit more and we're talking about the government rectangular survey system? So now we move from lot and block with subdivisions to the government rectangular survey system. How many sections are in a township in the government rectangular survey system? 36. Hey, Zavna. 36 of those. Carolyn's here. Yeah, everybody's here. So yeah, 36 sections in a township. Now, how many acres are in each section of that township? Savna didn't have to wait for me to finish the question. She is on it with the 640, right? She is on it with the 640. All right, great. Jerry is researching the laws that regulate the types of uses or activities that can be undertaken in various areas of his community. They are called, are they plat maps, surveys, zoning ordinances, or building codes? What do you guys think? These are the types of things we can do in certain areas. Yeah, exactly. Zoning ordinance. Now, if the city is planning out the area and they're saying we're going to put this will be retail and this will be commercial and this will be industrial and this will be residential, and they're planning where everything's going to go in the and where all the neighborhoods are going to go, where everything's going to go, when they're laying out a plan for the city, what do we call that plan? The master plan is like the plan for the city to make sure that we're not all squished together in one area doing the wrong things at the wrong time, right? So Sally lives next door to a strip mall and a Target store. There is a strip of land separating her neighborhood from the commercial area. This is called a what? Is a buffer zone, setback requirement, brownfield, recovery zone. Which one is it? Buffer zone. Sometimes people get buffer zone and setback requirement mixed up, but the setback requirement is like in my neighborhood, I have to be this far away from my neighbors' lot lines, that sort of thing. But the buffer zone is when I'm transitioning from one kind of zone to the next kind of zone. So government regulations specifying a minimum construction and building standards to safeguard the health, safety, and welfare of the public are known as, is it dedication, disclosure, taxation without representation, or building codes? These are talking about the minimum construction and building standards to safeguard everything. Yeah, these are the building codes. So we do this. They put these building codes in place. These are a type of police power. They're telling us what we can do, what we can't do. We got to make sure that everything's up to code before we let people move in, so it's safe and happy. Now, there is a word on here. It's not the answer to this question, but let's see if anybody knows this one. If I am a builder and I give streets, or I give land to build streets on in the neighborhood that I just developed, right? I'm giving land to the city. I'm saying, here you go. This land is for the streets. I'm donating this for a park, whatever the case may be. Which one is that? Which word is that on here? Anybody know? Yeah, dedication. Yeah. So a builder might say, like, there's a neighborhood that's like right down the street from me, and they have a really cute little park on the outside of the neighborhood that this builder donated this land to build a little park to the city, and they built a little park there. That's dedication. Or sometimes when they dedicate land to building roads and things. Very good, guys. All right. Leslie has a restrictive blank in her deed that says that the property cannot be used to sell alcohol on Sundays. Is this covenant? Is this chattel? Is this cooperative? Or is this fixture? All right, you guys knew this. The covenant, right? The restrictive covenant. But what's chattel? What's chattel a synonym for? Anybody know? Personal property, right? Personal property. Chattel is just personal property. Very good. Very good. What's the difference between a cooperative and a condominium? If I live in a cooperative and Sherry lives in a condominium, what's the difference? Yes, you don't own the real estate in the cooperative, right? You own the real estate when you own a condominium, but in a cooperative, you own shares of stock in the company that owns the building, and then they assign you a certain kind of lease. If I live in a cooperative, what kind of lease am I given? A proprietary lease, right? It's a proprietary lease. So if I live in a cooperative, the type of lease that's assigned to me is a proprietary lease. Just know that goes with cooperatives. All right, guys, next we go. The city of Happyville is planning their yearly budget. Like most local governments, most of Happyville's operating money comes from is it income taxes, property taxes, state taxes, or federal grants. Which one would it be? Income taxes, property taxes, state taxes, or federal grants? Where does most of their moolah come from? Property taxes. Property taxes. The following are examples of encumbrances on a property except liens, mineral rights, easements, special assessments, liens, mineral rights, easements, or special assessments. Which one of these is not an encumbrance on the property? This is kind of tricky, but everybody's getting it. Yeah. Mineral rights. Why are mineral rights not an encumbrance? Because they're right? An encumbrance is something that's holding me back. It's keeping me from doing what I want to do with my property. It's like, you know? So a lien is an encumbrance. Why? Because I owe somebody money. And if I sell my house, I got to give part of the money I make off the sale to paying off that lien. An easement. I'm letting Christina use my driveway. She has an easement that's holding me back because when Christina's driving down my driveway, I can't be driving down my driveway, right? It's holding me back in some way. A special assessment would be an encumbrance because I owe this money to pay for the sidewalk upgrade or whatever in my neighborhood, whatever the case may be. Right, exactly. Good job, guys. Tony is a developer that likes wide open spaces. When building a new subdivision, he included a clause in the deeds to the properties he sold that stated no fences were allowed in the neighborhood. This is known as a deed. Is it subordination clause, marketing technique, restriction, or conveyance? Yeah, it's a deed restriction. And many of us have deed restrictions. If you live in certain neighborhoods, they might have more than others, right? My dad has a restriction about fences in his deed, you know? What if Tony puts this restriction in the deed and then uh, William moves in and they start to put up a fence, okay? Or Dominique moves in and she puts in a fence and the neighbors look at that and they're like, wait a minute, Dominique, you're not supposed to have your fence over here. Right? What are they going to do? They're going to be like, Dominique, stop with your fence. And what control do they have? What can they do? Can they call the city and be like, Dominique got a fence? Does the city care? No, they don't care. I'm like, whatever. Yeah, they can take it to court. They can go to the court and ask the judge to stop Dominique from breaking the restriction. But the city isn't going to send out the police or the building department or whatever to stop her. But yeah, if it's something like that, yeah, they can require them to take down the fence. They can give a fine. They can do whatever they can. But normally it's that if in the situation with the deed restriction, the judge would order that she stop breaking that restriction, right? By removing the fence and discontinuing the fence. Yeah, that's pretty much probably what's going to happen there. All right, which of the following would not be determined by zoning laws and regulations? Is it how big structures can be? Whether land can be used for commercial purposes? The way in which a buyer can take title? Or where buildings can be located? Yeah. What do you guys think? So the way in which a buyer can take title is not determined by zoning laws and regulations. That is not determined by that. So all these other things would be determined by that. Yep. All right, good job. Beth has moved into a new home in Happy Acres subdivision. All of her neighbors' homes are built about 25 feet from the road. And why is this? Is it county building codes are requiring that? Is it setback requirements in the subdivision regulations? Is it just coincidence? Or is it zoning rules in the city? Yeah, setback requirements for sure. Yeah, the setback requirements are keeping them saying, hey, you've got to be 25 feet from Nicole's yard. You've got to be 25 feet from William's yard. We got to keep these distances, right? So we're not on top of each other. So the different subdivision regulations might say something differently. Very good, guys. All right, Janet's Curl and Dye Hair Salon has operated on Baker Street since 1967. This year, the area, which used to be commercial, has been rezoned residential. is it if Janet's shop is allowed to continue to operate as a beauty parlor, what most likely has happened? Is it Janet got a variance? Janet's shop has been granted a non-conforming use. Janet got a building permit. Janet ignored the city officials and just kept showing up to cut hair. What do you guys think? We got mixed answers on this. Now, remember what's happening here. Now, this is an interesting question. So, her shop has been granted a non-conforming use because when she started, she was following the rules. This area was allowed to be a commercial area. Yeah, you know, and then it came along and they changed the rules on Janet, right? So Janet's Curl Up and Die has been doing its business. And all of a sudden the city comes along and says, nope, 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 we're changing that. Now it has to be residential. Now, it wouldn't be fair if they said, Janet, just go curl up and die and don't do your hair anymore. So they're going to allow her to have a grandfathered in or a non-conforming use. But if Janet had wanted to put her hair salon there before, and she already knew that it wasn't allowed, but she was asking for them to allow her because of some hardship, then that would be the variance part. Okay, cool. We got that one. So the local telephone company has built power lines across the rear portion of Farmer John's cornfield. This type of easement that the telephone company has is called is it adverse possession, trust account, easement in gross, or contract or deed? What do we call this? It is indeed an easement in gross, but why? Why is it an easement in gross? What makes that an easement in gross rather than just a regular old easement? Only one piece of land is involved, right? Right. Yes, there you go. Yes, no dominant. There's no dominant and servient here. One piece of land. So a utility company or the railroad track or whatever is benefiting, the railroad company or whatever is benefiting from this easement, not another piece of land. If one piece of land benefited from another piece of land, then that would be a typical easement. But here in easement and gross, it's like one piece of land is involved and it's not benefiting a second piece of land. So it'd be like a right of way for utility a lot of times. Okay. You guys may or may not know this one. The National Environmental Policy Act requires that federal agencies prepare a what for any development project that the federal agencies could prohibit or regulate. Is it a tax abatement, an environmental impact statement, a township master plan, or a planned unit development? Everybody's kind of sitting and thinking about this one. We had some mixed answers here. Yeah, the environmental impact statement. We need to make sure that this is not going to have a negative impact on the environment, any endangered species in the area, anything like that. So the environmental impact statement would study that and make for sure before we started to do anything. Awesome, guys. Typically passed by a city or village council, these laws are called, I feel like I'm on Jeopardy. Typically passed by a city or village council, these laws are the HOA rules, deed restrictions, ordinances, covenants. What the heck are they? What are these? All right. Yes, these are ordinances, right? If it's a local law, like I live in Middletown, there's certain laws, and I'll say that this is in Middletown, this is the law. The speed limit's here, this and that and the other, right? Those are passed by the local government. Versus there are some laws that are across all across the state of Ohio, whether I'm in Middletown where I live or in Cleveland at the top of the state, doesn't matter. That's a state law. That'd be more like a statute. That's the word we use for that. But local laws are ordinances. Very good, guys. The owner of a property places a condition in the deed that there can be no new buildings erected on the property for 20 years. What is this called? Yeah. So deed restriction, right? We've kind of talked about this a couple different ways here, but it's a deed restriction. Yeah. A valid exercise of the government's police power to restrict an owner's use and enjoyment of property includes as a deed restrictions, covenants, deed conditions, or building codes. Now, this is the government's police power. Be careful, guys. Not the builder, not the developer. Yes, this is the building codes because these other three, the covenants, the deed restrictions, the deed conditions, all of those things would be put there by the former owner or the developer or the builder of that property. But the building codes are government, right? They're the ones the government puts there. Okay, great job. Diana, a developer, is working on an exciting new development in her community. It will include a mixture of housing, retail stores, and office space. What is this kind of development known as? It is a strip mall, a planned unit development, a plat map, a condominium complex. Which one is this? We're going to use a mixture of stuff, housing, retail, office space. There's several of these in the area where I live. Yeah, they're called plan unit developments. They're planned that way. So we have everything mixed together. So it's kind of, kind of trendy right now to have it so that, hey, I can walk out of my front yard and shop and get my lunch and run to the library. All these things is laid out that way. Very good, guys. All right. So the city took Saul's property with just compensation so that they could demolish it to make room for a new highway exit. This taking of private property to benefit the public good is known as what? Restrictive covenant, highway use tax, deed in lieu of foreclosure, or eminent domain. Yeah, so this is eminent domain. The local zoning ordinance of Sarah City define the required distances between the lot lines and improvements. So the local zoning ordinances in Sarah City define the required distances between lot lines and improvements. These are known as, are they setback requirements, buffer zones, frontage, or depth? Yeah, these could be put there by the local zoning ordinances or the developer, whichever the case may be, setback requirements. Yep, for sure. What does it mean when I talk about road frontage? Like if I say Stacy's property that she has listed has excellent road frontage, why do I care? Why is that good if that listing had excellent road frontage? What would be a situation where I would really think that was awesome? What do you guys think? So a commercial property, right? Mostly. Road frontage is how much the commercial property faces the road. So think about it. Have you ever been driving down the road and you're not really thinking about Chipotle, but then you're driving down the road and you see a Chipotle. I need a burrito, and you have to just like pull off right away and get. And you wouldn't have been like, you would not have normally gone to Chipotle, but you saw it. It's right there. You can pass it by. But if Chipotle had been hidden behind the Walmart building and you couldn't even see it, then you're less likely to do that impulse turn around and go Chipotle, right? So that road frontage is important for when it comes to commercial buildings because it gets people suckered into coming in and buying something they wouldn't normally have thought of. So Alan owns a property with riparian rights, but no prior appropriation rights. Which of these could he not do? From the doctrine of prior appropriation, which of these could he not do? Use the water to irrigate his garden, dam the water to prevent others from using it, swim in the water, or boat in the water. What could he not be allowed to do? Now think about what, if I have a doctrine of prior appropriation allows me water rights, I may be able to keep others from using them. The riparian rights, I cannot keep others from using it. So I would not be allowed to be like, I'm going to build this dam right here and keep everybody else. I'm just going to keep all the water to myself and anybody downstream to heck with them. Can't do that, right? So riparian rights gives us water rights, but not so that we restrict others. Riparian rights go with what kind of water? Anybody? Rivers and streams, flowing water, right? Or for river? What about littoral rights? What are littoral rights? Go with lakes and oceans, right? Things with the tide and then versus the flowing. Very good. Very good. All right, guys. Fred has been hoping to move into his new home soon. He receives a document that the property has been completed and inspected and found to be habitable. What has he received? Anybody know? Is it a title certificate, a quitclaim deed, a certificate of occupancy, or a lieu pendens? Yeah, the certificate of occupancy. They're saying, okay, we checked it out. It's safe to move in here. Come on in, right? That's the certificate of occupancy. All right. When's the situation when we might use a quitclaim deed? What do you guys think? When's the situation that we might use a quitclaim deed? A divorce, yeah. The couple is splitting up and they want to take one person off the title that's leaving behind. What else? What if I have a cloud on my title? Cloud on title, somebody showing up on title that's not supposed to be there. We would have them sign a quitclaim deed. Yeah, for sure. Yeah, for sure. Let's see. All right, next we have dividing a city into zones, allowing different types of land use in different zones is known as Regulation Z, the zoning, police power, or escheat. Okay, zoning. Emma's land is blank. In other words, it has no access to the road. Is it adversely possessed? Is it appurtenant? Is it landlocked? Or is it a gross easement? Yeah, for sure. Landlocked. Now, Emma's land is landlocked. But if Emma had an easement over William's land, it wouldn't be. She could get to the road. And the judge says, you know what? It's not right to leave Emma back there to starve. We need to let her be able to get out. So he would likely grant Emma an easement by what, if she asked? to let her use William's driveway. What would they grant Emma? Poor landlocked Emma. Very good. Very good. Larissa got it. And an easement by necessity. Yeah, an easement by necessity for sure. Yep. There you go. And that's if it is necessary, right? It's necessary. Otherwise, she couldn't get out. And that would really stink. So anyway, you guys, good job tonight. This was land use controls. Very, very good. You guys did a good job with these questions.